starts now.
Good morning, Your Lordships. Standing before you is Council Harold Swanunda, Council for the applicants. In this case, that is Comrade Ogezi and 120 others.
With me is co-counsel Serubiri Ernest and counsel Namukwana Hope Sumaya. We're going to use a total of 30 minutes. I'm going to use 20 minutes to handle issues 1 and 2, and the other 10 minutes to handle issues 3. As a start for today, we come to start the Article 50 that gives any part of the Constitution has been infringed a right to come to a court of redress, and particularly we go under Article gives this High Court
unlimited original jurisdiction to handle
such matters. If it may please Your Lordship,
I would like to open up my case.
Proceed.
Much obliged, my Lord. In our day-to-day business, we live in a world of innovation and improving technology. We live in a world where data is being used day in, day out by the young, by the old, and by the elderly. We live in a world in business, in education, in our which is what video as the right to privacy is guaranteed before this honorable court. Of why we are here today. The main reason why we are here today is because our clients have
a right to privacy,
particularly data privacy, which has been breached by the respondents, being Professor Ogwang, being Infinity Analytics, and being the National University of Applied Tech, Uganda. My Lordship, it should be noted, as I said in the brief characterization, Professor Ogwang made a survey using
using an app known as BrainBook.
BrainBook was an app that was used by people to sign
in or sign up. And on that app there
was a questionnaire.
That questionnaire
was
a survey
about gambling practices
amongst the youths, and the
stakeholders and people that take part in
this gambling that took part in this survey
were giving their opinions on gambling practices that happened. I won't take long, my Lord.
What happened was the
fact that this data was
procured by Professor Owang using an app
known as BrainBook. BrainBook is an app that is under an uncertified
BrainBook Incorporation
that claims to be a company that operates in Uganda. But my Lordship, after this app being procured, by BrainBook, the facts of the Moot go on to show us that there was 2 different installments of sharing of such data. The very first time, BrainBook shares this data directly with Infinity Analytics. And secondly, after sharing such data, that happened for a scope of 2 years. Then later on, the CEOs of Infinity Analytics tell Professor Owang to create another app known as Your Life. Your Life was an app that was used to procure data from BrainBook, and such data was sold from Your Life to Infinity Analytics without the consent of the data subjects. My Lordship, with this, I would like to proceed with issue 1. The question that you have before us.
Council, perhaps could you first lay out all the legal issues arising from those facts, and then you can proceed.
Much obliged, Your Lordship. The legal issues arising from such facts, issue 1 being that whether the sale of data between Your Life and Infinity Analytics was lawful. Issue 2 being that whether the respondents, such as Professor Owang, BrainBook, Infinity Analytics, and the National University of Applied Tech, Uganda, are compliant with the existing legal regime. And issue 3 being that whether the applicants are entitled to the non-pharmacal order that they seek. And issue 4 being
whether the applicants are entitled to the remedies
that they seek before this
honorable court. Your Lordship.
Proceed.
Before me,
which issues will you be handling?
I'm going to be handling issue 1 and issue 2, and co-counsel will handle issue 3 and issue 4. Much obliged, Your Lordship.
These are the reasons as to why we believe that the sale of such data was.
What is your answer to issue 1?
My answer to issue 1 is that the sale of such data was unlawful, and secondly, there was no consent, and thirdly, due to those 2 reasons, there's breach of data privacy. Much obliged, Your Lordship. First of all, for us to answer to issue 1, we need to understand the reasons as to why such sale was illegal. Section 37 of the Data Protection and Privacy Act is to the effect that no person shall sell user data in any way. And subsection 2 goes on to criminalize such an act by giving a penalty for selling of such user data. That is the first premise of our argument. But then again, second, you need to understand that to procure an argument of breach of data privacy, you need to look at three different parts. The very first part, Your Lordship, being the collection of such data, the second part being the processing of such data, and the third part being the sharing of such data without consent. And that is what I'm going to be dealing with in issue 1. And my Lordships, by the time I'm done with issue 1, I would have also solved 85% of issue 2. I beg to proceed. Moving on, the very first thing you need to understand that data itself, in the very first instance, was collected without consent, and the applicants don't actually say anything to that. But where we have a problem with consent is the second collection of such data that was procured by Infinity Analytics from Your Life app, and also the sharing of data from between BrainBook and Infinity Analytics app. But again, another point of contention I have before this honorable court is that for a person to collect data or data collector, they must be certified under the Data Protection and Privacy Act. That did not happen with BrainBook Incorporation.
Counsel, the issue you framed concerns the sale. So I would request that in the interest of time, you stick to the issue of sale.
Much obliged, my lordship. Yes, much obliged, my lordship. So I will proceed with that. The second sale of such data was procured without the consent of the data subjects. The Act clearly defines, when talking about consent, that consent should be clear and unambiguous. So,
yes.
What section of the Act?
Section 2 of the Act that defines consent. I'll read for you verbatim if you don't mind, Your Lordship.
No, you can just paraphrase.
Oh, all right. With paraphrasing, consent should be gotten unambiguous. It should be freely expressed and gotten from the data subjects directly. That takes us to section 11. Section 11 of the Data Privacy and Protection Act is the effect that data shall be collected directly from the data subject. That was not procured, that did not happen, where Infinity Analytics gets data not from the subject, but from Your Life app, but from BrainBook app. That, my lordship, is the absence of consent. Consent is a very strong thing that's actually brought out in section 7.
Counsel, have you addressed your mind to the exceptions under section 11.2?
But yes, Your Lordship.
What do the exceptions say?
There are very many exceptions, Your Lordship.
Such as?
One of them is data could not be gotten directly from the data subject, where it was not practicable to get such consent.
Counsel, have you read the contents of section 11?
Yes, Your Lordship.
And the exceptions state what, sir?
Your Lordship, the exceptions under section 11 are up to paragraph G. There are very many.
So don't you think in this context, the information actually does fall under one of those exceptions?
I do not think that, Your Lordship.
Why do you not think so?
Why I don't think so is that the very first exception is that the data should be contained in a public record. This data was not contained in a public record, but rather in a private record. Why? Because people had to sign up and give in their passwords. Among this exception, a public record is data that has been put out, like the Uganda Bureau of Statistics, data that's going to be accessed by anyone of the public when they want to access it. That is not the case right now. Right now, you cannot access this data. I cannot access any of my clients' data if I don't have their username or password. That falls short of the requirement of public record. But the other exception talks about that the data has... Oh, I was going to look at all the exceptions and show how none of their cases fall within that. Moving on, the second part that shows that the second necessity is that data should be collected for the same reason as to why, data should be processed for the same reason as to why it was collected, particularly section 17 of the Data Protection and Privacy Act. This was breached as according to the facts. Professor Owang processed this data in a psychometric model. A psychometric model procession was to the effect that such data can be later on sold for commercial purposes. What do I mean, my lordship? If you go to any of my clients, 120 people, and ask them, when you filled in this survey, what did you see? They will tell you that they're only giving their opinions about gambling. None of them at any one point saw them helping another firm to do market research. Why? Because if you look at the app, if you look at the instant
Counsel, are you saying that in principle it's illegal to use? Counsel, are you busy?
Pardon me, lordship.
Are you too busy for this court, counsel?
No.
But you're well aware you're coming for a court session.
Yeah,
Maybe that's what you're for.
Apologize for that, your lordship.
So is it your view that in principle the psychometric model does not fit within the requirements of the Act and that it's illegal?
Yes, it is my view, and as why I would say it is my view is because the requirement of the Act under Section 17 says that
Data should be processed for the, it should be, it should not, the processing, the further processing of data should be in line with the original reason as to why data was procured. The original reason as why it was procured, it was for academic research. But the processing in a psychometric model was fitting the wants of Infinity Analytics, because at the very beginning, Infinity wants to make an app known as Yomula. Your app that is going to rival other mobile money products. So a psychometric model helps them create such market research data that will help them do such an app. And the mere fact that such sharing of data was monetized, it makes it for commercial purposes and outside education purposes. So none of the subjects could really have seen the data.
The question is simple, that in principle,
Yes, Your Lordship.
this court declared that it is illegal for any data collector to use a psychometric model.
No, Your
Simple
Lord.
as that.
In principle,
Yes.
that would be a two-way argument. It would be illegal. It is legal to use a psychometric model if it is matching with the same reason as why you collect such data. But at the moment you use psychometric model in a reason that is different from the reason why you collect it, then it's illegal in principle under Section 17, Your Lordship. Much obliged, my Lord. Wrapping up with issue 1, the other part I want to talk about is I already talked about absence of consent. That's what I want to stress about mostly. You see, when data was being shared between your life and Infinity Analytics, there was no consent from the data subjects for sharing such data. Section 13 of the Data Protection and Privacy Act is to the effect that Section 13 is to the effect that information has to be certain information. Section 13 subsection 1 gives out information that should be given to a data subject before you collect such data, which includes the name, the address, and everything of the sort. I would have talked about Brainbook having no address, but I was stopped from doing that by Your Lordship, so I will not talk about that. What I will talk about is that there's an exception to that. And the exception is that if data is to be procured by third parties, that is under Section 13 subsection 2. If it's to be procured by third parties, Your Lordship, then the information in subsection 1 should be reprovided back to the subjects. And under Section 13 subsection 1, part of the information is the reason as why you're collecting your name and address. It's basically talking about consent. Consent is an issue that we need. I would like Your Lordship to look at the issue of consent as something that is actually very important.
In this application, is your challenge that they should never have sold this data, or that they should never have sold this data without consent?
My challenge, first of all, is that they should never have shared data without consent. But then again, secondly, they sold data, which is illegal under Section 37 of the Data Protection and Privacy Act. It is a two-way challenge, Your Lordship, because the issue says whether the sale was lawful. Before this honorable court, I would like to establish, based on Section 37, not on my own authority, that first of all, sale is unlawful. But even if there's a situation where a sale could be lawful, there's absence of consent.
But counsel, if Section 37 is clear that sale is unlawful, which other instances can the sale be argued to be lawful?
There's no other instance, Your Lordship.
So why are you arguing this?
The reason that's why I'm arguing this is because our main cause of action before the honorable court is a breach of the right of privacy. If I show how sale itself is illegal, but then I fail to show that there was breach of privacy, meaning my clients will not get entitled to the remedies they have.
I think these are two different issues, and I think you stand a risk of confusing this court if you keep relating these two issues, which are clearly distinct, counsel. Section 37 is clear. I wonder why you are belaboring on an issue that is actually very, very clear, counsel.
Much obliged, Your Lordship. Thank you for that, Your Lordship. Moving on, I would like to invite the honorable court to look at the case of Basaja Balaba Yakub versus MTN Uganda Limited. In this case,
That's the full citation of the case. Could give us the full citation of the case
And the facts of the case, briefly.
Your Lordship, I've misplaced where the full citation is. I have a brief, but I can give the facts of the case if Your Lordship
How can we
wishes.
find it?
For the record, counsel.
Would prefer that you cite the case whose full citation, and these facts, you know.
Yes, Your Lordship. Alright, the facts of this case was Masaja Balava.
Counsel,
Yes.
if you are unable to provide the citation, cite a case whose citation you can provide and give us the facts.
Yes, Your Lordship. Alright, moving on to issue number 2, whether the parties are compliant with the existing legal regime, regulatory regime. Your Lordship, we should note that the current regulatory regime we have before us is the Data Protection and Privacy Act. The other regime we have before us is the Constitutional Republic of Uganda. And the other regime we have before us is the National the Data Protection and Privacy Act and the Constitutional Republic of Uganda. That's what I will basically face my arguments. As already said, as already discussed in issue 1, the reasons as why we think the parties are not compliant with the regime are very simple. The very first reason as to why it is because data was collected in a manner that infringes on the privacy of the data subjects. This is because consent was not procured. Section 10 says that data should not be collected. Section 10 of the Data Privacy and Protection Act says that data should not be collected in a manner that infringes on the privacy of the data subject. And as already proven, the respondents reached that. Yes, in the first instance, but not in the second instance, Your Lordship.
So if
And-
the submission comes that this data was collected twice from the subject.
Your Lordship, it was my submission at the start of my issue saying that data was collected in 2 different phases. And I said we don't contend with the first collection, but we contend with the second collection done by Infinity Analytics from Your Life app, Your Lordship. Much obliged, Your Lordship. Moving on, there was unlawful processing of such personal data by Professor Owang specifically for commercial purposes, which differs from the original reason of collection that was academic research. Moving on, there was a gross violation of...
But are we certain that this is the kind of data that had all those requirements under the Act? Is this really personal data in view of the facts?
yes, much of...
From your own submission, this was data collected for a psychiatric work.
Yes, much of...
It's just genuine information.
Much obliged, my Lordship.
I would prefer that you first listen to the question.
Right.
This is really just genuine information about the person. And so, how certain are we that it fits within the meaning of personal data under the Act?
Much obliged, my Lordship. For purposes of precision and accuracy, I would want to read what personal data is under the interpretation. Personal data means information about a person from which the person can be identified. I will stop there. I won't go any further. Personal data is data that is unique to a person, whereby if they get that data, they can identify who this person is. But how am I relating this to the data that was collected?
Take us to the facts.
Yes, taking us to the facts, I'll read them off head. Taking us to the facts, data was collected.
Paragraph.
Yeah.
Not very ideal.
Paragraph 5, Your Lordship. Paragraph 5 stated that data was collected. Okay, let me read for you. Paragraph 5 says that Professor Owang, for his research project on consumer preferences, designed a questionnaire and conducted a survey using the Brain Book platform to understand personality traits and collected information from various stakeholders. One of the data, some of the data that was collected by Professor Owang falls. Oh, much obliged. Data that was collected by Professor Owang falls within the metric of special personal data. Special personal data is data that identifies someone, for example, their political affiliations and their financial spending habits.
And that's according to what legal authority?
That is according to Section 9 of the Data Protection and Privacy Act that talks about special personal data. So, data that relates to someone's religious affiliations, political affiliations, and financial spending habits falls within the ambit of special personal data. And as all defined personal data was defined by data that can be used to identify someone that is special to that person. So someone's political affiliation, someone's financial spending habits are special to them and fall within the ambit of special personal data and also fall within the ambit of personal data, Your Lordship. With that, I would beg to yield ground to my co-counsel who will substantiate on issue 3, issue 3 and issue 4, and will make the appropriate prayers for our clients. Much obliged, Your Lordship.
Thank you, counsel. It's always respectful to wait for your time to sit before you rise. Which also means that counsel should speed up.
Much obliged, Your Lordship.
proceed.
My Lord. I pray this court is priest. My name is Sylvia Ernest, and I'm counsel for the applicants. I'll handle issue 3 and 4, and I'm going to start with issue number 3. Time, I'll use 10 minutes, as earlier stated by my colleague. Issue 3 states whether the applicant is entitled to obtain the NOIC pharmaco order that they seek for. And actually, we are the applicants that are seeking for that order. Much obliged. The NOIC pharmaco order was defined in the old case of...
What's your answer to the issue?
My answer is we are really... we deserve to be granted that NOIC pharmaco order.
You who?
The applicants, my Lord. The NOIC pharmaco order was defined in the old case of NOIC Pharmaco Company versus Customs and Excise Commission. It's a 1974 case. In this case, they held that
Can you get the full citation?
it's NOIC Pharmaco order versus Customs and Excise Commissioner, 1974.
Before what court?
My Lord, I
Give us
beg
the full citation and the court.
much obliged. It's Norwich Pharmaco Company versus Customs and Excise Commissioner, 1974. SC 1033. It was held
AC meaning
appeals committee, appeals court, appeals court.
Counsel, are you sure? It's in my big shape.
Do you wish to retract that statement?
Yes, my Lord, I wish to retract that statement and
What does SC stand for?
I beg to consult counsel.
To consult counsel, this case was held in 1974, and the act in question that you have over there, I think came into force in 2019. Has this court, by any chance, made any decisions in regards to that particular case?
Yes, my Lord. Much obliged. It was held, this same issue was handled in the case of DFCU Bank
Yes.
versus MTN and others.
Before-
Messiah's application. It was in the High Court before Justice Mr. Tekana.
Okay, give us the brief facts and then proceed.
The brief facts in this case, MTN, Airtel, and Afcel applied to court that DFCU had leaked information of their clients as they are sending messages. So in this context, they applied to court so that they are given such orders to check on the actions of the defendants, my Lord.
What information was sought by the applicant in that case?
Yes, in this case, if someone is opening up an account, they give their personal data, which becomes user data. So in this context, it was linked with the mobile telecoms in order to ease communications as you bank.
Counsel, the question is very simple. Which information did the applicants in that case seek?
My Lord, I beg to pardon me the question.
In the case you have cited,
Yes,
DFCU versus MTN, decided by this very court, guide us on what information exactly was sought by the applicants in that case. Who are the applicants in that case?
The applicants DFCU Bank.
Yes. So what information did they seek in that case?
They are seeking.
And counsel, was the order granted in that case?
The order in that case.
Before we get to the order, what information?
It was personal data, my Lord.
Which personal data?
Personal data of the client.
Which one?
Like?
Did you make a case?
I
I read the case.
If you read the case, you know the principle of faith,
Yeah.
and you know which data.
You can also yield to self-constant, proceed to the holding.
My lord, I'll beg to proceed with the holding in this case.
So you yield.
So you have decided to ignore our question.
Not necessarily a legal question, but in few of areas in law and misquoting law.
But if you read counsel, how do you misquote the law?
Okay, primarily, okay, thank you very much.
But the reality is it's not wise for you to proceed. Because in my mind, I'm still worried. What was the information? So
The information primarily their telephone numbers, my lord.
Are you certain?
Personal data will not be just the numbers, but in that very case, it will not be just
Yes, as going back to my earlier submission as I stated, these clients were seeking for personal data, and this personal data included telephone numbers, their names, and nationalities.
So in this application that you're now making, what information do you see?
In this application, as in regards to the facts, my clients applied their nationalities, their religious affiliations, political affiliations, and their spending habits, my lord. And
so they want the respondents to tell them their nationalities. I want to be certain.
Yes,
If we are to issue this Norwich pharmaco order, which you see, what information should it be discovering?
much obliged, my lord. In this context, we are
What do they
seeking.
want to know? In that
Yes, we are seeking this order to check on how your life ascertained the data that is sold to Infinity Analytics, whether it really are abided by all the legal requirements.
What are those legal requirements?
Legal requirements are stated under Section 3 of the Data Privacy and Protection Act.
The legal requirements for obtaining the order or the legal requirements?
The legal requirements that they have ascertained before they get deposit data. Yes.
Take us to those legal requirements.
Much obliged. Section 3, it states the principles of data protection. The data protector must be accountable. The data collected and processed, it must be collected and processed fairly. Data collect, process, use or hold adequate, relevant, not excessive or unnecessarily personal data.
So in this particular case, in view of those principles, you want to know whether they adhere to accountability?
Not really, my lord. In this regard, we are asking, for example, when our clients gave in their data, it was primarily for academic purposes, and it's a principle that such information should be kept for a reasonable period of time. So it's my submission, my lord, that this data, if academic purposes had got done as it was the main principle, it was prudent for the respondents to erase such data. Much obliged, my lord.
Counsel, Counsel, in relation to the agreement, was it stated somewhere that even after them giving their personal data, it should be for a specific period of time?
My lord.
Secondly, you seem to be seeking for the Norwich pharmaco order, but is there any other remedy that you can ask this court to give you in case the Norwich pharmaco order is not possible, or it may take long? Any other remedy you could?
Yes, primarily, Section 98 of the Civil Procedure Act gives this court coherent jurisdiction to grant orders. And such orders, in this context, we shall ask for discovery of documents under Section 64 of the Evidence Act. This was stated in the case of Karhang and another versus the Attorney General and two others, in which it was stated, if I can read verbatim, it was a Ms. Niasko's number 0060 of 2015, in which it was said that discovery is contingent against a party's reasonable belief that he or she has a good cause of action or defense. In this regard, my lord, it's my submission that in
Are the
regards
requirements for discovery different from the requirements of an NPO?
primarily I was answering question of
Yes,
my lord
now we
when he
want to
stated
know.
that any other remedies that we would seek in Ugandan jurisdiction, my lord.
Please answer the question.
Yeah, the question is, again, very simple. Are the requirements of discovery under the law different from the requirements of an NPO under the law? Guide us on the two.
Primarily, when you're seeking for discovery, it's in most cases in terms of private documents. So in this context,
In most cases?
okay, much obliged, my lord. In this context, in terms of discovery, we shall seek for much obliged. I humbly ask for 2 minutes to sum up my submission.
And then you'll have an extra minute to summarize issue 4.
Much obliged, my lord. In this context, we ask for discovery in terms of private documents. So in this context, we are before this court, as a matter of the fact that this private data and their private documents in this context, we ask for court to grant our people the discovery order, which differs from no Ifamako order, because the no Ifamako order, it's mainly if someone has a reasonable cause of action. So they seek this order to be granted access to information. So they might see, they are different in one or another, but as His Lordship has asked me, it was prudent for me to give him any other remedies that we would seek for.
If you could briefly just bullet the 3 conditions.
The 3 conditions under the no economic order: 1, a good arguable case; 2, the defendant must be mixed up or facilitated the wrongdoing; 3, likeliness to provide such information, and of which the respondents can
Beautiful. So
provide
in
that.
the case that you cited of DFCU versus MTN and the like, was the order given as the justice asked?
In this regard, the order was not granted under DFCU versus DFCU Bank versus MTN on basis that Justice Sekana stated in his judgment that it wouldn't be prudent to give out such data in case all parties to the case have not consented to this. So my reason for bringing up this case.
Right there, counsel. If I'm not mistaken, over 1 million people gave that data. You have 120 people as your clients.
Exactly, that's why.
Why then should we give you consent, yet you don't even have 50%?
Primarily, I brought in this case to try and define how no economic order was attempted to be applied in the Ugandan jurisdiction. So the case wasn't binding, but rather I was persuading court, my lord.
The case is not binding.
It's binding, but I was trying to persuade court in relation to the facts, because facts are kindly related.
Is there any other case in the Ugandan jurisdiction in which this court granted the NPO?
My lord, in my research and reading, I realized there are some cases, like for example, Mwema versus Facebook, Ireland, but though it's not, it was held on a foreign land, that was Ireland, hence making not a Ugandan case, but specifically it's DFCU Bank versus MTN that I got in my research, my lord.
Proceed.
In 1 minute, issue 4.
Much obliged. I'll proceed with issue 4, whether the applicant is entitled to the remedy sought. My lord, we ask for injunctions. As much as the fact that our client's data is in process for this long.
How many?
Pardon me, my lord.
You said you're asking for injunctions. I'm asking how many injunctions?
Injunctions, I'm asking for an injunction to the respondents. Yes, Section 38 of the Judicature Act gives this court authority to grant such injunctions.
To do
and
what?
to grant injunctions to deter the respondents from a continuous wrongdoing.
How many injunctions are you asking?
Injunction, primarily I'm asking for.
You can put a name to it.
What type of injunction are you asking?
I'm seeking for.
Are there different types of injunctions, or there's just one type?
There are different forms of injunctions.
So which
There
one do you want?
in this, there are interim injunctions. There.
Which one do you
Which
want?
one do you want?
We're asking for interim injunctions, my lord.
Interim.
Pending what? Interim, pending what?
Pending the judgment, as court will issue judgment.
Okay.
Yes, I'll proceed in the case of Kagu.
No,
You don't have to. Any other remedies?
Any other remedies would seek for compensation under Section 33 of the Data Protection Act and Section 27 of the Computer Misuse Act. Specifically, we shall seek for general damages and exemplary damages.
And you're also seeking compensation under Article 50 of the Constitution.
I'm much obliged, my lord.
Why are you proceeding under Section 33 of the Data Protection and Privacy Act and not under Article 50 of the Constitution to seek for that compensation?
As earlier stated by my colleague, he stated the jurisdiction of this court, and he stated Article 50. I do beg.
I think you're misunderstanding the question. Why do you seek your compensation under Section 33 and not under Article 50?
Yes,
Or are you seeking under both?
I'm seeking my compensation under Section 33 because it's the immediate law that we are approaching in data protection, my lord.
How about Article 50? Why not under Article 50?
I addressed myself primarily on Article 33 because it's an immediate law that supervises this court in this application, my lord.
Counsel, I heard you talk about the Computer Misuse Act.
Yes, my lord.
Which particular provision?
It's Section 27 of the Computer Misuse Act.
What does it state? And why do you need this in relation to this particular point? Just in a few seconds.
Much obliged.
Well, it's one thing to cite something, but it's another for it to be relevant.
In this regard, we're asking for this under Section 27 of the Computer Misuse Act. It states that if someone has misused data or a computer in one way or another, they would come to court to seek compensation in regard to the misuse or the wrongful act. Yes, I'll proceed in this regard.
Counsel, you don't have much name. Just
Yes, I'll paraphrase.
the other remedies, if any.
Yes, general damages. This was backed up in the case of El
List the
Talem.
other remedies.
I will seek for and also exemplary damages to deter the respondents from doing such acts, and they act as an example. And we pray this court that the respondents suffer costs for this suit and any other remedies that this court might deem fit. Much obliged, my lord.
Thank you, counsel. Do you wish to respond?
Yes, my lords.
Proceed.
Much obliged, my lords. My lords, appearing for the respondents, I am Dalton Chisule, together with Tracy Naiga and Sarah Crescentia Nachia. My lords, I'll be responding to issues 1 and 2 and raising preliminary objections before the lordship. I'll be using 20 minutes of this honorable court's time, and my co-counsel, I'll be addressing you on issues 3 and 4 shall use 10 minutes of this honorable court's time. We shall also exercise our right to rejoinder, my lord.
If they withdraw.
Yes, my lord. My lords, the brief facts as known by the respondents are that Infinity Analytics, a data consultancy.
Unless you want to make any clarification as to their statement of facts, simply proceed to the legal arguments.
Much obliged, my lord.
You want to make any clarification?
Indeed, my lord.
Point that out.
Particularly, the applicants omitted to bring it to your attention that Infinity Analytics, in its intention to expound the niche markets and develop digital innovation in this country, entered into a partnership with the university. Much obliged, my lords.
Is that all? As far as the clarifications are concerned?
My lords, I shall clarify more as I submit before your lordships.
Proceed.
Much obliged. My lords, your respondents raised a preliminary objection to this particular suit inasmuch as the applicants do not satisfy the pecuniary jurisdiction of this honorable court. My lords, your Your respondents posit that the applicants have not satisfied the pecuniary jurisdiction of this court. This court has unlimited original jurisdiction, but it is the position of the law that an act that expressly ousts the jurisdiction of this honorable court shall have matters handled first in it, and that was the holding of the Supreme Court in the case of Rubble Enterprises versus Uganda Revenue Authority. My lords, it appears, as seen in Section 33 of the Data Privacy and Protection Act, that a party aggrieved by the actions of a controller, collector, or processor shall appeal to a court of competent jurisdiction for compensation. Unfortunately, the Data Protection and Privacy Act does not clarify what a court of competent jurisdiction is. Fortunately, my lords, the Human Rights Enforcement Act, as seen in Section 4, subsection 1D, posits that the High Court shall try all matters pertaining enforcement of rights, provided they are far above the pecuniary jurisdiction.
I feel maybe when you are on these circles, why don't you proceed to your substantive arguments? Because you raise an order and you respond to it. I mean, an objection, then you respond to it. As the other side would have, I think you should just proceed to your substantive arguments.
Your objection is not.
Much obliged, my lord. May it please your lordship that I raise an additional objection.
Proceed.
My lords, the applicant's suit, Offence Order 1, Rule 8, as they proceed in a representative action without satisfying the requirements of this honorable of the civil procedure rules as amended.
That is also noted.
Much obliged, my lords. Proceeding to the merits, as enunciated earlier, I shall be dealing with issues 1 and 2. Issue 1, which is whether the sale of data from Your Life to Infinity Analytics was unlawful. My lords, your applicants.
Answer to that issue.
Our answer, my lord, is that the sale was lawful. My lord, the applicant, my land, rather the first speaker for the applicants. Much obliged, my lord. The first speaker for the applicants did bring it before this honorable court that this particular collection of data from Infinity Analytics was not direct collection in line with Section 11 of the Data Protection and Privacy Act. My lords, we contend that this particular collection falls within the exception in subsection 2B. My lords,
What is that?
my lords, subsection 2B of the Act reads that the data, notwithstanding subsection 1, personal data may be collected from another person, source, or public body where the data subject has deliberately made the data public. My lord, to answer this particular issue effectively, I would have to refer you to Section 13 of the Data Privacy and Protection Act, which enunciates some of the requirements needed for a person fairly collect data, and among them is the identity of the collector, the purpose, and what type of data is required. My lords, referring you to the facts, particularly at paragraph 3, Infinity Analytics, in its particular desire to expound niche markets, enters into a partnership with the university. The university, my lords, as seen at paragraph 5, in its attempt to understand consumer preferences, does, through the Professor Owang, collect particular data pertaining these particular preferences through questionnaires, my lords. This particular data, through the psychometric mode of collection, reveals to the person submitting their data what type of data is collected, who is collecting it, and for what particular reasons. And suffice to say, my lords, as seen at paragraph 12 of the facts, Comrade Wagwez himself admits that the professor did approach him for data for research. To that end, my lords, it is our submission that this particular data was made public. deliberately.
Does it matter that the data was password protected for each of the users?
Yes, my.
Okay. So, does that have any? Because to make it part is to put it on a free platform which anyone can access.
Yes, my lord.
But now this was only accessible to your clients. This information was only accessible to your clients. It's not that they went to the newspapers and published for everyone to know.
Yes, my lord.
This information was collected by a particular person.
Yes,
So
my lord.
within the meaning of that provision which you read, was the information really made public?
Yes, my lords. Our contention is that this particular data was made public, provided that a person who desires to access this particular data can apply to get it, but then its grant has to be within the ambit of the law, and your respondents would then have to consider the
In
lawful
principle,
provisions.
What would you understand by making this data public? Is it to make it accessible to your client alone, or to make it accessible to the general public? What is your construction of that provision?
My lords, to make data public is to lay out data to the public.
Yes, not necessarily to disclose it to a third party. If you disclose it to one third party, as the applicants did,
Yes, my lord.
trusting that the third party is aware of the law and will observe the law,
Yes, my lord.
you can't necessarily say that that has to make their information public. They really didn't.
Yes, my lords. Our contention is that even the third party falls among the segment of the public. If the applicants had wanted us to erase, correct, or even give them back their data, we could have done so, but it does not appear anywhere from the facts that such an application was made for the grant of that particular data to the applicants, my lords.
Let's proceed to the cell.
Much
Because
obliged.
I'm more interested in that. It's what is in issue.
Yes,
Right?
my lords.
Yes.
Our
Council cited section 37. What's your response?
Our response is that the law is clear in section 37 that no person shall offer for sale any personal data. My lords, the qualification in that particular section is that data that is prohibited from sale is the personal data, my lords. When you go to section 2 of the Data Protection and Privacy Act, my lords, personal data is defined as information that could wholesomely lead to identification of an individual, my lords. My lords, when you go to the facts as seen at paragraph 5,
But I don't know which rule, which actual provision you're reading, or which rule of interpretation you're reading, because that provision does not state anywhere that it must wholesomely identify. It simply says it should be able to identify, not to wholesomely identify, which means something completely different. So I guide us to that construction.
my lords, I shall take your guidance and restate my statement that data to amount to personal data, it must ably, as you said, my lords, identify that particular individual. But evidently from the fact, my lord.
But still, again, counsel, guide us on the perhaps some structure of statutory interpretation, because the statute does not use the word every.
Yes, my lord.
It simply says identify.
Yes,
So
my
we
lord.
are wondering where you're getting all these extra words that sufficient, that conveniently favor you.
Much obliged, my lord. I was working on your indulgence. I'll read the particular provision verbatim to your lordships. It reads that personal data means information about a person from which the person can be identified. And thereunder it goes on to list.
Which principle of statutory interpretation do you want us to apply in understanding what is meant by identifying a person?
My lord, I would prefer the literal principle of statutory interpretation to be applied by your lordships, by using the natural meanings of these particular words used in this statute to reach to the conclusion that data or information must identify an individual for it to be personal.
And counsel, even if I were to take you on that specific aspect, that specific rule of interpretation, counsel, that section you're reading goes ahead to look at data instances that actually define what personal data is, and they talk about the education level, specifically under B, the education level or occupation of the person. And to take you back to the fact, specifically under paragraph 6, it appears that this data was collected on the basis of different professions, which in the interpretation of section 2B does appear to look at the aspect of it, the education level, occupation of the person. So counsel, within that context, don't you think that data that was collected around different professions, the personality, location, tastes and habits, does actually fall under the definition of personal data?
Yes, my lord.
So if you claim, if you accept, if you concede that aspect, don't you think that by virtue of section 37, indeed personal data was sold? And as you prepare to answer this counsel, I remind you that it is okay to concede on an aspect that is very clear from the facts, counsel.
Much obliged, my lords, and I'll take your guidance, your lordship. And our contention, alternatively, is, my lord, that this court applies its inherent jurisdiction and apply to these particular facts the doctrine of severance, my lords, and dislocate from this particular data collection transaction the elements of illegality and leave that standing those components which are legal. Because, my lords, the essence of this particular collection is to boost innovation, is to boost technological advancement, and it is to boost the economy wholesomely altogether.
I don't see how you answered that question. You just seem to be rotating around that question. So you could just answer, is the data that you collected, does it fit under section 37 in regards to personal data? Because your client collected data concerning financial habits, political affiliation, this and this.
Yes, my lord.
So does it fit under section 37 in regards to personal data?
Much obliged, your lordship.
Just get straight to the point without, because your time is.
My lord, it does.
So you concede.
So that's a concession, counsel.
Unless you can prove to us otherwise.
Yes, my lords, it is a concession. And in the alternative, I invite your lordships to apply the common law doctrine of severance and sever from this particular transaction the illegal element of sale, because the particular processing, my lords, was in line with the legitimate interest. Even the transfer to Infinity Analytics was to boost the niche markets. Infinity Analytics.
It was in line with legitimate interest.
Yes, my lords.
So selling people's data is legitimate interest because you collected it for academic purposes. Later on, your client sold it.
And made us with some precedent on that doctrine of severance.
Much obliged, my lords. In Simon and Johnson's.
First answer this question.
Much obliged, my lord. My lord. My lord, I beg your pardon.
Okay, briefly.
Yes, my lord.
Your client collected personal data.
Yes, my lord.
And you claim that was for academic purposes. I will still take you back to this question. I don't know the answer to this question. You answered it, that's probably a bit under that. Now you collected it for academic purposes. Later on you sold it.
Yes, my lord.
So does that fit in what you say in relation to legitimate interest?
Yes, my lord. My argument for that is that under the under the data protection and privacy regulations, legitimate interest is defined at Regulation 4 as that particular further processing that could be reasonably expected by a data subject. My lords, at paragraph 6, if this particular data was collected specifically for research and then, unfortunately though, sold to Infinity Analytics, but still to research the niche markets and your mula, my lords, that falls within research and analysis because Infinity Analytics is actually a data consultant.
So does it fall under legitimate interest that you sold personal data?
My lord, that particular component does not, and we invite your lordship to survey it and bring into conformity the remaining transaction, my lords.
I am interested in your doctrine of severance.
Yeah, because you seem to keep going back and forth, then you bring the regulations, then you do this. So tell us more about the
Much obliged, my lords. The doctrine of severance is a common law doctrine where the courts, when it comes to transactions that are partly lawful and partly void, the court can sever from that transaction the illegal bit, provided it does not go to the root of the particular.
So guide us with some precedent on this.
Much obliged, my lords. I refer you to the Australian case in Brooks versus Barnes, Philip, trustee, reported that
what's the citation? What was brief fact? Yes, and which principle? Just briefly, because you have 2 minutes left.
much obliged, my lord. It was reported that Australian High Court law reports at page 432 in 1969. I said Brooks versus Barnes. Barnes Philip, trustee. Barnes Philip, trustee.
At page?
Reported at page 432, my lords.
By which court?
The Australian High Court.
Decisions of the Australian High Court relevant before the High Court of Uganda?
My lords, they are persuasive in nature and non-binding on your lordships.
Under what law can we consider them given? We
You
want
can-
to be sure that it's possible for us to consider such a decision.
My lords, you could consider them through the Judicature Act, section 13 and 14 of that particular legislation.
Okay.
Much obliged, my lords.
Following your doctrine of severance, I want you to specify to this court what exactly you want us to sever.
In view of that decision.
Much obliged, my lords. I invite your lordship to sever the component of sale, to order, to give an order redoing or undoing the particular sale and rendering that particular sale in as much as it is contingent to the data or attached to the data unlawful. This could be by way of a refund to the purported to the
purported counsel.
no, my lord. It could be by way of a refund of the particular amount to the buyer of the
But
data.
in this very case, that buyer has already had advantage of this information.
And the client's right to privacy has been breached.
Once information is disclosed, it cannot be undisclosed. So even if us cancelling this transaction means that there is no way that works out of this clean. They've already had advantage of this information. Even if we say let them destroy the information, they've already seen it.
Much obliged, my lord. An order could emanate from this particular court ordering the rectification, the destruction.
Can we order that they forget this information out of their mind? They delete it out of their mind because they've already seen it.
My lord,
In my view, conceding on this, I don't know how we can even survive. Because from their mind, the information is already there. Even if they've stored it in whichever storage device.
And the damage has been done already.
much obliged, my lord. My lords, the right to privacy, as enunciated in the general comment on Article 17 of the ICCPR, is that privacy entails, in the modern age, it entails the traditional right, it entails data protection, and at the utmost, it also comes with the right to be left alone or forgotten. My lords, in destroying this particular data, all components, all aspects on this particular data shall be actually eliminated from existence. I invite your lordships to derive persuasion.
The traditional sense of right privacy, but we no longer live in the traditional times. We now have social media, and these people's data was stored in a certain place.
Yes, my lord.
And then it was sold without their consent.
Yes, my lord.
So even if we were to destroy their data, still, I mean,
the deed is done.
yeah. And now with software coming into, it seeps into right privacy. So you cannot really argue that in the traditional sense we can sever and destroy. You get what I mean?
My lord, if my understanding...
Just answer the question, because your time is fast finished. Answer the question and you conclude.
My lord, my understanding of the right to the privacy traditionally is that personal space, non-intrusion of premises, and then in the...
So if someone were to hack into your bank account details and was able to see your balance, or was able to see your messages on Instagram and Facebook, would that be a violation of your right to privacy?
It would, my lord, and it would also equally fall in the data protection.
So you wish to retract your earlier statements?
My lord.
You forgot your earlier statement.
Not really, my lord.
Okay, in 1 minute.
Yes, my lord.
Sum up what you have said. Sum up what you have said on issue 2 and then you can answer.
Much obliged, my lord. My summing up specifically on issue 2, which is whether the respondents were compliant.
Sum up on issue 1. What have you said?
On issue 1, my lords, my arguments have been that this particular transaction was in line with the exception in section 11, subsection 2b, and this particular further transaction or further processing, Infinity Analytics, was in line with the section 12, read together with section 17 of the Act and regulation 12, my lords.
On issue 2?
On issue 2, my lords, which is whether the respondents were compliant with the regulatory framework, my lords. It is our submission, briefly, that the respondent professor in his collection of data through the brain book was acting as an agent for the university, which is actually a registered collector and processor. Infinity Analytics, to this end, my lord, was acting as a data recipient in line with the Act, who is not required to actually undergo registration with the Personal Data and Protection Office. My lords, if I'm of no further indulgence, I'll yield the floor to my co-counsel.
Much obliged, your lordships. As earlier introduced, my name is Naiga Tracy, second counsel for the respondents, and I shall handle the third and fourth issue in 10 minutes. Your lordships, the third issue is whether the applicant is entitled to the no-wish pharmacal order that they seek from this court. It is the respondent's position that the applicant should not be granted this order for failure to prove that they need this particular order for what they are alleging they need it for, and also for failure to prove the elements that they have listed.
So what are they alleging that they need this particular order for?
Much obliged, your lordship. Under paragraph 13 of the facts, the applicants allege that they need the order to obtain information from the data used in the development of their life. Your lordships, this has not been proven by the second counsel for the applicants. Your lordships, I would like to first drive you back to the case cited by my land brother, DFCU Bank Limited versus MTN Uganda Limited and others. Miscellaneous application number 640 of 2019. Your Lordships, I would like to point out the fact that my land brother has erred in the facts of what happened in this case. In this particular case, Your Lordships, the matter concerned a propagation of fake news by the defendants. Your Lordships, in this case, one of the parties, DFCU Bank, had bought shares of had bought parts of Crane Bank. So one of the people of Crane Bank paid some people to propagate false news, and those news were later on given out to other people through his WhatsApp number. And that is how MTN, Airtel, and Africell come in, because they were the means through which he was distributing this information. Your Lordships, in that particular case, Justice Musa Sekana highlighted one of the things that need to be in place for this court to grant the Norwich Pharmaco order. That is that the applicant should not be ambiguous in the data that they require. Your Lordships.
So is that decision binding on this court, or we can depart?
Much obliged, Your Lordship. That decision was in this very court by Honorable Justice Musa Sekana, and it is binding.
The question is very simple. Is it binding, or we can depart?
It is binding, Your Lordship.
So we can't depart.
But the High Court cannot depart from its previous decision?
Much obliged, Your Lordship. The High Court can depart from its previous decision if the facts of the matter at hand are largely different from what was held previously.
So we can, in that case, he didn't grant the order, but in this case we can't grant it.
If the applicants are able to prove that they actually need the order, which they have specifically failed to do so. Your Lordships, as I was saying, in this particular case, it was stated that the applicant has to be very specific of what they need. The applicant has proceeded under paragraph 13 again to show that they need information from the data used in the development of your lives. Now, the question that is raised upon reading that particular paragraph is what information? What are they going to use this information? That brings me to the purpose of this information. The earlier case that is cited, Norwich Pharmaco Company versus Excise and Customs Commissioners, 1973, the House of Lords of the UK highlighted that this order will be granted where the innocent third party holds information that is vital to the case. The applicants under paragraph 13 have ably failed to show that the information that was used in the development of your life is very paramount to their case, and failure to be granted this order will destroy their case. Your Lordships.
So in the Norwich Pharmaco case, was the information so vital to the case?
Much obliged, Your Lordship. The information was.
In what way?
This information concerned importers. There was a patent, and there were people that were importing using that patent. The Commissioner of Excise and Customs had the information regarding those persons, and the defendants needed that information to know who was working in their name first and foremost, and who was breaching the statutory requirements of the UK. And that is what...
But in this case too, lawyers have the information of everyone else to share the data with. Just like in that case, the Commissioner for Customs had information about all those inputs. So why shouldn't we use the same principle? Since your clients are the ones who share the information, we know, and we can, on the same breath, make a similar order.
Much obliged.
How does that case differ from our facts?
Unlike that case, in that case, the applicant ably proved that the Commissioner had the information, and this information was going to be used in their case. The applicants in this present case, Comrade Wagwes and the 120 others, have failed to prove that there is even information that they require. They're just alleging...
Are you saying that there is no correlation between what they have sought and pursuing their claim for compensation? Because all they want is disclosure for who else you've shared this information with, so that they can better make their case, just like the Norwich Pharmaco Company sought. So are you saying there's no correlation between what they seek and their case, pursuing their claim?
Much obliged, Your Lordship. Your Lordship, identifying who else the data was shared with is far different from identifying the data that was used in the development of an application. An identity is, let's say, a person, a company. The data that was used in developing something does not fall under those two ambits. Much obliged, Your Lordship. The second council equally noted that there are three requirements that have to be proved as per the Norwich Pharmaco Company versus Customs and Excise Commissioners for this order to be granted. Firstly, a good arguable case. Secondly, the defendant must be mixed up. And thirdly, the defendant must be in position to grant the information. Your Lordships, I shall under Section 101 and 102 of the Evidence Act of Uganda, the burden of proving specific things, such as these elements, falls squarely on the applicants. The applicants, second counsel in specific, has failed to discharge this burden. Your Lordships, even
so you're saying in this case your clients are mixed up, is no wrong, they're mixed up here.
Much obliged, Your Lordship.
Even when your colleague has just confessed to us that there is a sale which occurred,
Much
and
obliged.
he was even pleading with us to sever that sale. So there's a clear wrong from your colleague's submission.
Much obliged, Your Lordship. In these elements, the three elements are cumulative. Failure to prove just one element will make it impossible for the court to grant this order. There are three elements, Your Lordship, and in the first case,
We are engaging you on the specific one of being mixed up in the wrong. We don't want you to recite for us the relevance. We're now being particular on one of those elements. Your co-counsel has told this court that there was a sale which was not proper under Section 37 and that we should sever it. Now, coming to your issue, doesn't that automatically equate to your client has already committed a wrong? Or within the meaning of that case, your client is now mixed up with that wrong, which you want us to sever. So I want you to harmonize with his submission.
much obliged, Your Excellency,
Yes.
Your Lordship. I'm going to go to my co-counsel's submission, but I shall first proceed to the applicants. Your Lordship, as I've earlier stated, the applicants, in as much as my co-counsel stated that probably there was a wrong,